Okay, when this guy was called into that court, it's basically going to be a show cause. The invitation from the attorney was not a warrant for his arrest. It didn't force him to come into that court. It was a simple invitation like, we'd like to hear from you. Please come into this court and bring with you your UCC-1. Look at it this way. That court in equity had already assumed and presumed that the dishonor of the father in not coming to the public tribunal was a mirror image of the dishonor of the wife not responding to the father's private administrative process. And when the wife didn't respond to the father's private administrative process and he got a certificate of protest and put public notice in the UCC, that was the wife's fault for dishonoring the husband and not trying to resolve the problem. But then when her attorney went into the public court and the court basically summoned him to come in and talk to the court about this same circumstance, he dishonored the court by failing to go into the court. So the court said, what's good for the goose is good for the gander. The father sanctioned the wife for not appearing by a UCC, so we'll sanction the father for not appearing to the wife and the mother by way of a court judgment of default. Now the civil court is trying to resolve the problem which resulted from two wrongs: the dishonor of the mother to the father and the dishonor of the father to the mother. But remember, in equity, it's a commercial accounting which deals with last in, first out accounting. So who was the last party to commit the dishonor? The father. So he is the next one treated an honor to come back into the court to try to resolve it, which is why they sent him this summons or this letter. Now his daughter says to me, since our friend's in jail, what are we going to do? Because I don't know if we can do any paperwork and process. And I said, well, you've got a letter sitting there, and that could be a time bomb. You have no idea what's going on. And if she would have followed other people's advice, she would have just let those letters sit there time out, and they would have gone back to the attorney and back to the court and not been accepted and dealt with, which would have resulted in what? A dishonor. Now that they tried to honor the father to resolve the state's problem, which is a conflict of their public filings, if he dishonors them this time in the civil process, what would be the state's next option? Criminal. You see a pattern developing here? And who was it that was helping this father and this daughter with this paperwork? Our hero, the guy in jail up in Michigan, and he's going to be brought down here to another state, and he's going to be charged with racketeering and conspiracies in yet another state. All of these are felonies with long prison terms. Furthermore, it's not doing the so-called patriots any good having wacky people not following through and understanding this whole process. So when this daughter opened the letter and said that Dad's been asked to come down with the UCC-1, I said, well, what is going to be your response? And she immediately said, well, do we have to accept it for value and return it for value and ask for settlement and closure? And I said, yes, that's part of it, but that's not the whole process. And I said that any time you're doing an acceptance and a return, think of it in terms of the two-part process, confession and avoidance. Your common law pleading. In confession, you're stating that all the facts in the pleading are true. But then you're going to add some more facts because you're saying the conclusions of law in the pleading are not right. So what you're going to do is you're going to give more facts to the court so that the court can adjust its assumptions and presumptions with respect to its conclusions of law or its charges. Now, we were thinking about that this week, and here's what we've looked at. Every pleading by an attorney in a court is colorable if they've done it right. In a colorable pleading, I think, like we said last week, it's a little bit country, it's a little bit rock and roll. It's not all of one thing. So in a colorable pleading, it's a little bit law and a little bit equity. So when the plaintiff sends a charging instrument, civil or criminal, they are giving you a pleading in which all the facts in that pleading are true. The true facts represent the law portion of that pleading. Then they assume and presume a conclusion of law, which, because there are no facts connecting the acts and actions to how they arrived at the conclusions of law, the conclusions of law, being pure equity, are assumed and presumed, and there's no facts associated with them in the pleading. Consequently, the pleading is law in facts, equity in assumptions of charges or conclusions of law. Now, let's sit back and think for a moment, which part of the pleading do you agree with, and which part of the pleading do you disagree with? Do you agree with the facts in the pleading as stated? Answer is yes. Do you agree with the assumptions and conclusions of law in the pleading as stated? No. Are you in harmony with the law portion of that pleading then, or are you in harmony with the equitable side of that pleading? You're in harmony with the law side of that pleading. Let's go to criminal pleadings practice. When you come in and plead not guilty, what does that just admit? That you disagree with the facts in the charges. Remember that the offender, the one that's got this colorable pleading, isn't he the creditor? Didn't they honor him? If he's the creditor, can't he really establish the court then the way he wants it? You bet. How does he do that? He tells the court what he wants in his response. If he wants a law court, he agrees with the facts and disputes the presumptions. If he wants an equitable court, he disputes the facts and agrees with the presumptions. So when the offender goes into a criminal court and pleads not guilty, isn't he telling the court that he wants to argue the facts? When he tells the court, I want to argue the facts, he's told the court, let's proceed in equity, because I have no dispute with the conclusions. If he comes in and accepts all the facts as true and pleads guilty to the facts, adds some extra facts, which are also in law under the rules of evidence, and submits them to the court, isn't he requesting that they change the presumptions of the conclusions of law in the charges? So he's voting to have a law court and to do away with the assumptions and presumptions of equity. So what you see going on here with the average offender who comes into court and pleads not guilty, he has just elected an admiralty equity tribunal for criminal proceedings. And what is the inherent characteristics of an equitable court? We only deal with assumptions and presumptions. We're not interested in the facts. Don't try to give us the facts. Our minds are already made up. Which is why you could go into the court and argue statutory law. Aren't the patriots good at that in tax cases? Well, here's what your own law says. Excuse me, we're not a law court, we're a court of equity. We're just dealing with assumptions and presumptions, and the assumption we're dealing with is it's not fair for you not to pay your share. Now, can you explain to us why we shouldn't put you in jail and fine you a big amount of money? Because you have no law. Excuse me, we do not deal with law in this court. If they told you the truth. You see what we're up against and what's going down? So remember our friend up in Michigan, literally when they said, would you agree to waive the probable cause hearing and arraignment by signing this paper so we can just send you up to the other court? And he goes, well, I accept for value, return for value, go ahead. And our hero, our one friend that's in jail up there says, I cannot understand why that guy did not object when they made him this offer. And I said, it's not about the facts in the offer. It's about honor and dishonor. And he's going to come back after the fact, add the extra evidence of his intent, put it through his attorney into the system, and proceed and go on. Now he's nullified everything they've done because he's come out and stipulated, how can I prevail and win if you want me to plead not guilty, which would state all the facts in the charging instrument are not true? How can I win when they're obviously as true as can be? So he is correcting that problem. Now, going back down to Indiana court, we have an interesting situation. The daughter said, well, we'll accept the paper for value, return it for value, and ask for settlement and closure. I said, that's great. That's exactly what all the patriots right now across the country are doing. They want to buy the justice. They want to pay off the court with their exemption. They believe that the state only runs the court for commercial purposes so that they can make or raise a revenue so that literally the state can finance its existence. And on the procedural public side, that's true. But remember, it takes a double witness. If the court started doing that willy-nilly, pretty soon what would happen is everybody'd come into court, recite the same thing. There'd be no one in jail. Everybody'd be out doing his own thing, and literally sin would abound because there is no one that's going to be the sounding board to keep sin in check. Do a murder, let's just go into court and offer them our exemption. No problem. I'll be out before they can finish the paperwork. You know, there was a problem in the Middle Ages. That was exactly what was going on. And you know what they called it then? The sale of indulgences. So what you're really saying is, let's just understand that we've got an exemption here. And now that we know that, we've learned the secret of all criminal and civil process. And we're just going to pop into the court, and we're going to say the magic words, buy the indulgence, because they are so happy to sell those indulgences to make a revenue that they'll never question us, and we could be back on the street in no time, sinning again. Your problem is that process of using the exemption is procedural. You also have to back it up with a substantive process, which includes the other 3 steps that I talked about earlier in terms of what it is that you're doing here if you're going to go home. Otherwise, this ecclesiastical court will not sell you the indulgence. Oh, they'll make the money anyway, believe me. But you will be in jail instead of out on the street because you're not going to, quote, buy justice, unquote, that easy. Does this make sense to you people? Now, here is our friends down in Indiana, and this daughter says, well, we'll accept the letter for value, return it for value, and ask for settlement and closure and use Dad's exemption and EIN account. Then she says to me, do you think Dad will really have to go to the hearing? And I am saying to myself, if he doesn't go to the hearing, that's the dishonor. They will come and arrest him. So I said it was no sense keeping that to myself, so I let the daughter know, no, you better go, or else he will be arrested, and then is when the criminal charges will come down, based on his second dishonor, his second contempt. Remember, you need double witnesses at least. So what she said is, gee, if I got to get Dad ready to go in there, I don't know if he will be able to say the right thing or do the right thing. So I said to her, okay, let's look at it this way. They made your dad an offer by sending him an invitation to go to the court. When your dad accepts that for value, returns it for value in writing, in an envelope, sent back to the clerk of courts, what has your father just done? Well, he honored the court, he accepted it, he appeared by paperwork. What does this paper now represent? Isn't it an agreement? Offer acceptance, isn't it an agreement to some matter? It's contract. If there was money to execute it, it was at least an offering, a covenant, an agreement. once it's offered and accepted and it's formally declared in writing and it's placed in the office of the clerk of the court, this is a full-fledged private contract with public witness, isn't it? Absolutely. So what you just did is you contracted into the public court, because they're the holder of the paperwork, and you're obligated to resolve a problem. What did the offerer want the father to do? Bring in a copy of your UCC-1 file. Now, do you really believe that's all they wanted to have done here? No, that's just the start. What is the problem that we need you to contract us with to resolve? Yes, number one, on the private side, there's two dishonors, one by each party. Are both of you parties going to remain lunatics, or are one of you going to redeem yourself? Number one. Problem number two with the public. Our records are in dispute, and we don't care how you guys settle your problem, but you're not going to screw up our state records at the same time. So, even though it was the attorney for the wife that put out the invitation to bring in the father, aren't all attorneys officers of the court? Aren't the officers of the court working for the state judicial system? So aren't they interested in resolving the state's judicial problems too? You bet. So this guy got a nice civil invitation. We got a private problem now, we got a public problem now, and it's just getting worse, nothing's getting better. Come on into the treaty negotiation and help us resolve a public problem and a private problem. What is your advantage in dishonoring that request and not going? None at all. Do you want to sue the public officials for messing with your private UCC-1 agreement? I don't think it was caused by the public officials. I think your dishonor to the wife is the same as her dishonor to you. You're both idiots, and you've caused the state a problem. Don't sue the lawyers. Don't sue the judges. Don't sue the prosecutors. Don't bring tort claims against the bar members. They're just trying to help you people resolve your commercial issues that may be very difficult for a lot of so-called patriots to comprehend. But until you show me where the bar people, either as attorneys, lawyers, or public officials, have actually caused you the problems that you did not actually cause yourself, then lay off suing these people, because you are the one that has to look in the mirror and resolve the issue. Remember, in the 4 steps, the first step is look in the mirror and admit you caused the problem. And if you can't start at step 1 and you start at step 4, you're working backwards and you're getting yourself into a lot of trouble. So here's this daughter, and I said, okay, if you're going to accept the offer and return it for value, what you're doing is establishing the contract in the court to resolve whatever the current issue is. So isn't that nothing more than the definition of a pleading? So in reality, you're responding and creating the official pleading in the court. And by merging your acceptance in writing over the offer and putting it back in the clerk's office, is that assumptive, presumptive, or is that in fact? In fact, then what you just have is a law pleading, not equity. Now that you have a pleading going back to the court, and if you're going to accept it and return it, and you want that court to look at the facts instead of presumptions, what do you have to do to that court? You've already accepted whatever facts are in the pleading. In this pleading, all it is a time to show up a place and bring your UCC. That was an easy one to accept. Hey, boss, I can do that. What is a negative averment and what does it do? It testifies, so it presents evidence. Unless you were crazy enough not to testify to facts or bring facts, all you're doing is reciting conclusions in your affidavit. But if you do your affidavit correctly and they're factual, you're bringing new facts which, if they're properly introduced, certified, brought correctly according to the rules of evidence, constitute true facts which are on the law side of the court. And a negative averment can do what? Rebut presumptions. Again, taking the issue from a court of equity into a court of law. Okay? Now, I said to her, you need to get your father to do a negative averment. Now, what kind of negative averment is good old Dad going to do? What's dear old Dad's problem? He's got to clear up the dishonor he made with this civil court. So what he needs to do is go down through the four-step procedure. Not backwards like the commercial prostitute patriots do, but like the person who is sincerely sorry on the substantive side for the error he has caused in the problem that he's created. He has to acknowledge that I did something wrong. I failed to come into this court. Then in step 2, he has basically got to admit and give repentance for what he has done. Step 3, he's got to ask for forgiveness or grace. And finally, in step 4, he needs to compensate for any losses or damages. So I think Dad can do the negative averment. That's not a problem. Now, as far as Dad is concerned in these courts that he's dealing with his ex-wife, what are the assumptions and presumptions that lie against him on the public side right now as a direct result of his dishonor? Number 1, they presume he's incompetent. Number 2, they presume he had no reason to contest the divorce. But for right now, the issue that affects the public and his future is the issue of his incompetence. How would the daughter and the father go about rebutting the presumption of his incompetence?
Didn't you say he had a competency by his private?
if he has had a competency exam by a publicly licensed psychiatrist, psychologist, or someone of that profession, could he not get a letter of advice on the stationery from that professional to be introduced into the court to rebut the presumption of incompetence? The only evidence that's in the equity court is an affidavit by his ex-wife saying he's acting silly and incompetent. Is she qualified professionally to determine whether or not he's incompetent? The answer is she's not professionally qualified to determine that, but her charge, when it's unrebutted, and because her ex-husband failed to even appear and is in dishonor, it is irrelevant and immaterial. So what he needs to do is get third-party witnesses professionally. Now also he could have character witnesses from friends that know him. And they could say, yeah, good old Charlie is slowing down, he's a little older, but I've seen him in day-to-day operation, and he can buy groceries, he can drive his car, it stays on the right side of the road, and I believe that he can carry out his daily functions, and that I do not believe him to be unable to handle these events, and even that testimony will give some weight. So we have negative averments, third-party professional letters or affidavits, and character references from friends. That would attack the presumption of incompetence. But you see, you've got a problem in that court already has made a judgment. And they said he's incompetent, and it's his fault for having failed to appear. So, what do you think the next good counsel might be to this daughter and this father when they show up in court or before they go to court? Is there anything else you might recommend that they might consider doing that would help the father out on the public side for what he's trying to do here? Any ideas? Ask for forgiveness from the court for not appearing to begin with. We presume he'll already have done that. Remember in the affidavit the 4 points of feeling sorry all the way down through correcting the problem. If he does exactly what we've said right now, have we resolved the civil court's private problem? How many people say yes? How many people say no? No yes votes, most hands went up. Yeah, we haven't resolved anything. He's making his claim, but the court's already got their judgment. Have we resolved the public problem? Absolutely not. When he goes into this hearing, who do you think's going to get creamed? He is. He was the last debtor, which they made a creditor to come in and give us the relief. He hasn't given the private side relief. He hasn't given the public relief. He's got all his evidence in there, and he said, I'll restore you, but he hasn't really resolved anything at all, and there's no pleading in there with the court to have the court fix anything. So merely accepting it for value, returning it for value, asking for settlement and closure, settle and close what? We got a judgment against you, sucker. Well, yeah, but we got, okay, you could pay us for all the damages. But how is that going to resolve the issue? What's the issue? Who's got title to the property? And the conflict of the records. So can we help our friend out? What should we ask him to do? Think like Solomon. Offer to give up the property. They said, bring in the UCC-1. Let's do better than that. Let's have Dad fill out a UCC-3 and assign the secured party's interest, Dad, to who? Let's just do it to the wife. Okay? If he assigns the UCC-1 to the wife, what has he just done in fact? He solved the public problem because they're in harmony. What did he do to the private problem? Took care of their problem. How?
By signing over the property to her, who she's already guardian.
Yeah, the state said she was the guardian. If she's the guardian, here's my UCC. He not only signed over the farm, he signed over the straw man, the birth certificate, he signed everything over to the wife. Isn't that what a guardian is? Isn't that a substantive, complete acceptance of the court decree? Full acceptance. Flat out. Completely. Has there any controversy left in the court?
No.
No. Does the court have jurisdiction other than to make findings of fact and conclusion of law? That's all it's got. You solved everything. Isn't that what a creditor is? Doesn't he solve problems? Is everybody in this room happy now with that solution? I see a bunch of mouths going, yeah, and then I see a bunch of heads shaking. See, this guy filed a UCC-1 to protect his interest in the property, didn't he? Why is he going to give it up? Okay, look at what this guy just did. If he walks into court with a UCC-3, what is the issue that the court is trying? No. If it was the title to the property, they'd have just given her the title and she'd have walked away with it. It's not the title of the property they're trying. It's his competency. If he signs over the UCC-3 voluntarily, are they going to accept that? If they accept it, they could only accept the act of a competent man. If they accept it, by accepting his offer, they've judged him competent. Do you understand that? Otherwise, they'd have to deny it because an incompetent man can't do anything. Let me ask you a question. Did they invite him to come to the court? Or did they tell the guardian to bring him in? Why did they invite him to the court? As a test. Remember that movie? Everything is a test. That's what they told you in Recruit. Now, it takes 2 witnesses for everything. The court judged him incompetent. They can't treat him incompetent until they have a second witness. Who has to witness he's incompetent? He does. So if he competently obeys the court and titles over all the property to his wife, and they accept that, they've agreed he's competent. But that's when it gets extremely interesting for the court. Because if they're going to agree he's competent, why did they appoint his ex as his guardian of all of his property? Riddle me that, bat people. Yes, when he signs over the UCC-3, he nullified the equitable decision of the court by replacing it with the law of competency in fact. Go back to Solomon. Solomon had a court case in equity. The first mother said, "It's my baby." The second mother said, "It's my baby." None of the mothers had birth certificates, photos, DNA, fingerprints. It was argumentative. It was hearsay. Being in equity, Solomon said, well, this isn't about reality. This is about the justice scales being equal. So divide half of the thing argued with on this side, half of the thing argued with on this side, and they can go home in equity and all be happy. To which one of the ladies said to Solomon, "No, no, I made an error. The baby is not mine. I have no title or rights in the property. Give all of the property to the other woman." The court said, "This is different. Take the property and give it to the woman who testified." Didn't the woman who testified claim it's not her baby? Why did Solomon award the thing argued about to the woman? She was the only one that replaced presumptions with facts, changing the court from assumptions and presumptions to true facts. And the fact she testified to was a lie, but the substance of the reason for lying was the true fact in law, proving title. Does it not say in Scripture that if you are not willing to give up your life, you cannot save it? If you are not willing to give up your competency, you cannot prove it. When he goes into court with the return of this paperwork and has a UCC-3 copy assigning the property to his ex, and will eventually get a UCC-11 of that out of the Secretary of State to certify to this court that he has in fact turned over his competency and all his property to the court-appointed guardian, which solves all of the civil and all of the public-private problems, the court will be forced to take the evidence of the fact of him doing that to rebut the presumption of incompetency, thereby showing he's competent even though his action looks incompetent by giving all his property away to a guardian like he could not handle it. If he is sincere about what he is doing, and the court operates at the level of understanding of Solomon, once he does this, putting the public and the private in honor, the court would have to strike its equitable judgment and replace it with a law judgment awarding him back his competency and property. Yeah, if he's competent, why would the guardian need to watch it for him? Now, this guy's ex-wife thinks that being appointed guardian over her husband gave her license